Hello, this is Mr. George. Welcome to Web Lecture 5.3. We are continuing our discussion about conflict and resolution, and today we're going to discuss the trial process. So what you have to do if you are accused of a crime and the process you go through to get your fair shake in the legal system, the trial process, and if you are convicted, then what happens when you are punished. Now, once there is the investigation and then the arrest, there is a pre-arraignment conference. Now, in the pre-arraignment conference, they give you an indictment, and the indictment is the charge that you are formally accused of. And this is the process by which they tell you what you're being accused of, and this is when you have that opportunity to get a lawyer, because and even prior to this, you can have a lawyer if they're just questioning you, but this is when you definitely need a lawyer because now you have officially been charged with a crime. Now, obviously, if you cannot afford a lawyer, as we've talked about before, then you can be provided with a public defender. This is court-appointed counsel. This is given to the defendant if you cannot hire your own lawyer, and the public defenders are paid for by the county or the state or the federal government, depending on who is prosecuting you. And a public defender is a board-appointed lawyer, and they are just as qualified as any other lawyer. They're just there to help people who cannot afford them. And so that's a public defender. Now, once you have gone through the indictment process, then you go to the arraignment or the pre-trial conference. And at the arraignment, this is when they take your plea of guilty or not guilty, and then they set your amount of bail. Now, bail is the money that you must pay in order to be released until the date of your trial. Now, if it is a capital offense, something like murder or something like that, the bail may be set very, very high, whereas if it's a smaller crime, then the bail is set lower. Now, remember, the bail is not you do not always have to pay the full amount of bail, because if you use a bail bondsman, you pay a portion of it, they pay it, and if you don't show up for your trial date, then the bail bondsman is out money, so that's why they would come looking for you. So bail is sort of like a deposit that makes sure that you will actually come to the trial. And so, as I said before, you enter your plea, guilty or not guilty, and that is stated by the defendant if you are being charged with a crime. Now, the record of when your court date will be is recorded on the court docket, and so this determines the time and the date of your trial. Now, if prior to your trial you believe that you do not have a case, or your lawyer believes that the prosecution has a really strong case against you, they may encourage you to take a plea bargain. And a plea bargain usually results in the charges that are being filed against you being diminished, and in order for you to plead guilty. And so oftentimes they will try to do that, particularly if they have a strong case against you, because it gets rid of the trial process. The trial process costs the county or the state or the federal government money, and so in the long run this just saves everybody money, especially you as the defendant who would have to pay a lawyer. Whereas if you plea bargain, then you're done. However, plea bargaining, you admit that you're guilty, therefore you have this crime on your record, and you must serve the time for the crime that you plead to. In the court, there are people that work in the court, namely the judge, and the judge, in most cases, does not make the decision of guilt or not guilty. They're the ones that preside over the court. They make sure that the lawyers follow the points of law, they give instructions to the jury, and they determine when people speak and how long the trial goes, that sort of thing. Now, in some cases, there is no jury, and that's when the judge determines the facts and then decides the verdict. But typically, in a larger case, there is a jury, and they're the ones that decide on the verdict. Now, also in the courtroom is the bailiff. This is the sheriff's deputy that keeps order in the courtroom. They call the witnesses. They're in charge of the jury. They're the ones that basically make sure that order is sustained in the courtroom. And then obviously there are the lawyers. The lawyers are the prosecution lawyers and the defense lawyers. They follow certain rules or codes of conduct, and they need to represent their case. Obviously, it is the prosecutor's job to prove the guilt of the defendant, where it is the defendant's lawyer's job to just basically play defense. They really don't have to present a case per se if the other side does not have strong evidence against them. Now, it's really up to the jury to determine whether somebody is guilty or not guilty. And if you are called to jury duty, then you are entered into what's called the jury pool. And every day that there are trials, the jury pool comes into the courtroom and they are selected. Juries of 6 to 12 people are selected from the jury pool, and you go through a questioning process, and they want to determine whether you are biased in this case, and if you are biased, then you certainly will not sit on this jury. However, just because you are not selected for one jury does not mean that you may not be selected for another jury. Because if you're not selected for that jury, you go back into the jury pool for the rest of the day until you are chosen or until your number is not called at the end of the day, and then you just go home. Once you're on a jury, your role is to listen to the evidence. You don't want to draw any premature conclusions. You want to listen to both sides the entire time that the court is going on. And you're not to discuss the case outside of the people in the jury. And so what happens is a lot of times, especially when it's a big case, is the juries are sequestered, which means that they are kept all together in one location. If it's multiple days in a hotel, they stay together so that they cannot see any outside influences, because that's the idea, is you want the jury to be as impartial as possible so they aren't biased by the newspaper or their neighbors or their friends or their spouses. And so this is what the idea with the jury is. Now, once the jury is selected, the trial begins, and the first part of the trial is the opening statements. This is basically the introduction to the two sides. The prosecution has their opening statement, the defense has their opening statement. This is just telling a little bit about what's going to happen throughout the trial. Then the real meat of the trial is the evidence. This is where the two sides bring to light what evidence they have, either to prosecute the alleged criminal or to defend the alleged criminal. And there's direct evidence and circumstantial evidence. Direct evidence is evidence that can be directly proven is linked. Circumstantial is evidence that kind of hints at the conclusion that they want. Once the evidence is presented, then there's the rebuttal. This is the argument that goes against the evidence that was originally initiated. And so once the defense rests their case, the government then can present rebuttal. They can present witnesses that rebut the case. They can give all kinds of testimony at this point. And so this is just a sort of counter argument to the original evidence. And then, finally, like a conclusion, you have the closing statements. This is when the lawyers bring up their closing arguments, basically wrap up everything they've said, sort of a summary for the jury to remind them of all the things they have talked about prior to the closing statements. Now, the interesting thing about the closing statements is at this point you cannot bring in any new evidence, which is a lot of times what they do in movies, which is why a lot of movies that have court cases involved in them are completely wrong, because a lot of times they will bring in new evidence into the closing statements, and you cannot do that. That is not something that can occur in an actual court of law. Then once all the evidence is presented, closing statements are heard, then it's now time for the jury to deliberate. They have their deliberations, they discuss, they debate, they all have to agree in order to find the defendant guilty. If one person does not agree that this person is guilty, then they cannot prosecute the defendant. Now, oftentimes it will not just be one person, and in the case if it is just one person and that person just will not change his or her mind, oftentimes what will happen is they'll call that a hung jury, which means that the trial is null and void and they will have to have a retrial. Now, once they do agree whether the person is guilty or not guilty, then they come up with the verdict. So after they reach their decision, they come out into the courtroom, they bring everybody back in, the judge has everybody stand up, and they give their opinion of whether the person is guilty or not guilty as based on the evidence that was presented in the trial. Once a verdict has been reached, that is the time for the sentencing. Now, typically, unless it is a capital offense, murder, first-degree murder, something like that, usually it is up to the judge to determine the sentencing. And typically the sentencing is not done on the day of the verdict. Usually they have another date where they're going to sentence or give the sentencing to the defendant. At this time now, if that person has been found guilty, the criminal, and the judge determines when that date is, and once that date reaches, it is then imposed on the defendant. Now, some cases, as I said, when there is a death penalty question, then that is often up to the jury because they do not want to leave that up to just one person, the judge, to decide if somebody is to be put to death. And then there is the opportunity for the defendant to appeal the case. Now, for appeals, there has to be some sort of legal basis for the appeal. It can't just be that the defendant is upset with the verdict. There has to be some sort of fact that the losing party felt that was not included, or there was some evidence that was tampered with, or some sort of cause that's outside of just, I don't like this verdict, I don't like it, and I'm going to appeal. So that is usually the case where there are appeals. Now, in a state court, there's another safeguard, and that is your appeal based on the fact that you feel that the courts have in some way violated your constitutional rights. And this is an appeal based on your writ of habeas corpus. And so your constitutional rights must be protected by the courts, and if you feel that they are not, then that is when you can file your writ of habeas corpus. And this is sort of like the ultimate appeal. If you appeal based on this, then there is a good chance that you may very well have an appellate trial, and that the conviction may be overturned.